express it in a language like English, you can think of alternative ways to say the same thing. If I'm interested in a place where a discount was involved, an expression like give a discount might certainly find some relevant material, but so also might an expression like knock off 10%, or reduce the cost, or rebate an amount, or how about some consideration? All these alternative ways are just a handful of ways we might think of expressing the specific concept. And yet, it's very hard to enumerate in advance all those possible ways. In fact, some studies have shown that if you ask about 20 people to think of different ways to name some common object, an object like this here, they might come up with 100 different terms to describe that object. And if you ask 2 people to say which their preferred term is, the chances that they'll agree on that preferred term are about 1 in 5. So it means that it's really hard for human beings to cope with this idea of dealing with or expressing what they want by using natural language and expect to get consistency or good results. Now, when foreign languages are involved, we have the additional problem that some terms that exist in one language may simply not exist in another language. That a word that may be used in English to express a concept might only be captured by some phrase or circumlocution in another language. There might be multiple alternatives that don't necessarily follow a predicted pattern. And this is true not just when we have exotic languages involved, but also when dealing with ordinary dialects within our own languages, English dialects, but say European language dialects as well. This presents a translation problem. And this translation problem is sometimes made worse by the fact that no dictionaries may exist to help with the translations. Think of the case, and this is close to an actual case that I'm aware of. When you want to look for something, say it involves a patent infringement litigation, that you might describe as a semiconductor alloy binding adhesive coating. How would you express that concept in Japanese or Chinese? And the answer is not that you would translate all those words I just spoke. In fact, the best methods for finding the concept typically involve mining documents that may be written in English that have that specific set of terms in them, but looking for the secondary and tertiary terminology that appears in those documents. In other words, creating a kind of cloud of additional terminology and using translations of those additional terms in a target language like Japanese or Chinese to find the relevant documents. So you may discover that there are concepts like surface texture or electron transport or layer compatibility that you would never have thought about, that show up consistently in documents that relate to the principal concept. Now, these methods are very difficult to describe in a way that makes a lot of sense when you're looking at the actual results. The results may bear no relation on the surface to what it was you thought you were looking for. There may be no mention at all of the specific terms that you thought you were starting with, but yet these documents may be, and in fact often are, quite relevant. So the problem from, I think, the point of view of making the case for this with courts is not just that it's difficult to explain how you would go about devising a search that's fair and appropriate, but making sure that you have access to the right kinds of tools. I mentioned Japanese and Chinese for one particular reason. Those are languages that are written without white space, without spacing between words. So if you look at some Japanese text, you have no way of knowing when you first look at the text where the words are. Well, that is to say the units that you would call the equivalent of individual words in a European language. And so the techniques that have been developed traditionally for dealing with Western languages do not well operate when applied directly to the free text that one finds in Japanese or Chinese. So there's not just a matter of using techniques that are more advanced, but also using tools that are appropriate for searching documents that may be in another language. This is a little different from the point that George made earlier about recognizing on the basis of a Unicode encoding whether or not the document you're looking at is English or Chinese or Czech. Those are important initial but low-level discriminations. But once you've decided you're looking at a document that's Chinese or Japanese, the next question is, how do you actually find information in it? Now, these are fairly technical and linguistic issues I've been talking about, but there's another aspect of this problem that is easy to overlook, and it's turned out to be very important in a few cases I'm aware of. And it really relates to the issue of culture and behavior. When we work, we don't just write documents. We engage in cultural behavior. And this can affect the kinds of things we end up producing. In fact, there have been studies in the business community about differences, cross-cultural differences in the way people relate to each other in organizations. Gerrit Hofstede in 1991 described what he called parameters of cultural difference involving such things as power distance, or whether a group tends to favor individualism or collectivism, whether there's masculinity or femininity in orientation. There's uncertainty avoidance, or there's some long-term orientation to information. And others have developed on top of this much more precise behavioral models involving things you would expect to see in an organization. How much formalization is there? How much of an organization hierarchy is imposed? Who's responsible for decision-making in a group? And these kinds of factors lead one to observe, and this might be just interesting from a conversational point of view, there are quite distinct practices in places like, well, the United States and Japan, or the UK and Germany. Now, we probably intuitively recognize that that's true, but where it becomes important is when people are leaving artifacts, information artifacts behind, we have to, we may be surprised that there are very pronounced differences in the patterns that are dictated by these kinds of cultural differences. So the range of products we produce at a company might include formal reports or spreadsheets or email and recordings. In a study of differences between Japanese and US practices, and this is this conforms to my observations directly, you're much more likely to have interactions in Japan than in the US that involve face-to-face meetings or tape recordings of sessions. The use of slides, PowerPoint slides, to describe new ideas. A lot of handwritten notes, a very large number of handwritten notes. Even spreadsheets that substitute as kind of note-taking devices, and extraordinary reliance on forms. This happens in Japan in part because there's a great deal of embarrassment, potential loss of face associated with making mistakes when expressing oneself publicly. And so we can get around that in a Japanese organization by creating forms that simply allow people to use what is 90% redundant from case to case and just make slight modifications that involve some subject matter. As you can imagine, if you were to do discovery on electronically held forms in a Japanese company, many of the forms would appear to most automated processes as duplicates of one another. But they wouldn't be duplicates. It would be only in some small parts of the forms that the critical information would be found. In contrast, the United States relies much more on formal reports and email and text messages than Japanese in practice. So this has a serious implications for where one would actually do a search, not just what terms one would use for a search, but the kind of information that one would target and the techniques that would be important to use for those different kinds of information would be different as well. So these are the issues that arise when dealing with not just formulating a search request, but actually executing it involving foreign language documents. So I think that somewhat in sum, the foreign language eDiscovery problem is especially difficult inadequacies of many traditional approaches to legal discovery and document production. This is true not just for technical reasons related to the type of search that's used and linguistic problems that arise when working with foreign languages, but it's also because of the cultural and behavioral factors that in different language communities result in different patterns of communication and information sharing and how such information is recorded. So I think one of our challenges is to educate courts and help them become a lot more sophisticated in developing standards for dealing with such information monolingually and cross-linguistically as well.
Thank you, David, for drawing attention to a very important aspect of eDiscovery that's also very often overlooked. Even when using those more sophisticated search methods, such as developed by Dr. Evans, one still might end up with so much data that manual review of those data by armies of attorneys will remain too costly. This past year, the eDiscovery world was abuzz with predictive coding as being the answer to expensive manual review of data. Dominique Jarre, to my left, is a partner in KPMG's Canada's forensic practice and the national practice leader of information management, eDiscovery, and forensic technology. Dominique teaches e-commerce and internet law at the HEC Montréal and Université de Montréal. He's a lecturer on electronic evidence at McGill University Faculty of Law. He trains Canadian judges from all jurisdictions and is a guest speaker on legal technology, IT law, privacy, cross-border data flow, information management, and eDiscovery at International Conference. Dominique, please tell us everything about predictive coding.
Thank you, and I'm now getting gray hair. I think we had a question just before I started our comment. That's fine. So really, predictive coding is more a buzzword than anything. It refers to a number of different technology to which we apply a methodology. The idea behind it is that we can auto-categorize, so to speak, in an iterative approach, a number of documents without reviewing or taking a look at all the documents themselves. So basically, if we look at personal information, information that could not be shared or for which we would need to seek the consent of the individual to which that information related, instead of having to look at each of the individual documents, perhaps there is a way to use what was referred to earlier as concept search. So look at the concept of personal information. Look at the concept of private information, of confidential information, of privileged material, solicitor-client privileged material. So by focusing on the concept rather than the words themselves, perhaps we'd be able to identify these documents that cannot be shipped abroad or for which we would need to seek the consent of the party. And often, when looking at large volume of data, but even in cases where we don't have such a large volume of document, we see that the mere keyword search is insufficient. For example, if we were to gather a number of emails from different people together, most of these emails may not contain any personal information. However, if we were to use a keyword such as confidential to find the document that are to be expected to be confidential, we'd probably be retrieving all of the emails, because most people have adopted lawyerly expression and notices at the end of their email saying the content of this email may be confidential. So in the end, we haven't achieved anything and we're being forced to go through all of these documents one at a time. What about instead looking at the concepts that are being discussed within each of these emails to try and extract those that truly have within themselves personal information. So rather than looking at the existence of a word within a document, we're going to look at what we call the co-occurrence within a document. So to simplify the notion of co-occurrence, we're looking at the relationship between words rather than the words themselves. And by doing that, we identify patterns within documents, and we can look through a large data set at this pattern and extract these documents based on the appearance or not of that particular pattern. To go back on something that David was alluding to earlier, one of the issues with keyword search is that it does not take into consideration what we call polysemy, which is the phenomenon where a word can have several meanings. And therefore, when you run a search, you're going to get a number of false positives, i.e. documents that are going to appear to be relevant when in fact they're not relevant. They seem to be relevant because they contain the word, but they truly are not because the word is used in a completely different meaning. Concept search enables you to find that exact meaning. Another issue is synonymity, where different words mean exactly the same thing. Well, and we've seen that in a number of eDiscovery cases where parties are going to agree to a list of keywords, and they have spreadsheets with thousands of keywords. These keywords are often useless because it's almost impossible for most human beings to think about every possible way in which something is going to be said, let alone the fact that people may mistype the document or use an expression or a scientific notion that may not be found in a dictionary. Once again, if you run a search with these keywords without taking into consideration the synonymity, then you're going to end up with false negative, i.e. documents you won't be retrieving that you should have been retrieving from your data set. So a number of technologies are used to do quote-unquote predictive coding, and I'm going to just give you a number of words that have, or expressions that have been used to talk about concept searching in a predictive way: intelligent or auto-categorization, suggested or predictive coding, which is really taken from the mathematical notion of predictive analytics, topic classification, review prioritization. And as you can see, all of these expressions on the back end use the same technology. It's the methodology or the purpose for which they are being used that change the name that are being given to them by vendors, software developers, and researchers. And behind these market words, there are a number of more scientific words that express the technology that are being used, amongst which latent semantics indexing, Bayesian statistical inference, support vector machine, etc. So there are a vast number of means by which we can predictively code documents. Now, practically speaking, how can we apply these technology efficiently? First way is in what we call a non-iterative approach, where we have a large set of documents and we don't know what they contain, and we're going to ask the software or the machine to look at all the documents and cluster them, create cluster out of whatever the machine field goes together. That's far from being good in a litigation or investigation environment where we're truly focusing on what is relevant to the case. The machine on day one doesn't know what is relevant. However, it may help the document reviewers to see these big patterns that the system sees within the document set. A more proactive way, and I think the favored way to use predictive coding is in a non-iterative approach. Actually, in an iterative approach. Leveraging the machine learning capacity. So for example, if we have 500,000 documents, normally we would have had to go through all of these documents. What we're going to do is we're going to identify optical representation of the reality and therefore the defensibility of the strategy that was used. Obviously that can be used in a vacuum and it requires some form of quality control so that the human being is not completely outside of the box. As I mentioned, documents reviewer or lawyers are still being involved in the process of reviewing the document. The beauty is instead of having an army of 20, 50 contract attorneys, we can afford to have only 2 or 3 more senior lawyers that know exactly what is key in that litigation or investigation. And they are educating the machine, thereby improving the quality of the calls made by that very machine. And at the end of that process, what we're going to do is do a last round of quality control, where we're going to extract from all the database another statically sound sample of documents and have human being review them and see if it's compliant with the margin of error that we've discussed earlier about, so that we're capable of showing that overall the result is greater than what we could have achieved with human being. Now to take these technology into the world of privacy, where I see the future heading is that instead of collecting the data, then processing it with these technology, what about if we could bring concept search technology and predictive coding up front? And for those of you who are familiar with the electronic discovery reference model, at the information governance cell, so really at the beginning of the process, so that whenever an employee receive a document or generate a document within the organization, the second they press on save, and it's being saved to whatever location, that document gets automatically tagged based on the concept that the software find in there. I can see that over the course of the next 3 to 5, maybe 10 years, which seems excessively long for that type of technology, based on what we've seen of its evolution. I think it's going to be realistic for many organizations to auto-classify certain type of documents based on the concept embedded in these documents. But obviously, the second we're going to start doing that, we're going to realize that there are other issues, other flaws that can be controlled. And so, still hoping that technology is going to help us overcome these issues rather than have to rely on an army of human beings, which often make the whole process impossible to achieve, and the rules a bit theoretical because they're being impossible to comply with.
Thank you, Dominic, for such a wonderful explanation of predictive coding. And now we're going to attack one of the culprits, one of the reasons why there is so much data out there and why it's growing and growing into some kind of monster, and that is social media. Many large corporations today have hundreds of Facebook pages, hundreds of Twitter handles, Google Plus pages. When there is a litigation hold, all the data on those accounts need to be preserved. Can the judge force a Facebook account holder to divulge his password so the parties can check out what has been posted on them? Can the judge subpoena Facebook so it should reveal a party's postings? These are some of the questions that Jim Dale will try to address now.
Well, the short answer to all those questions is yes, because in the United States, even before the recent eDiscovery amendments in 2006, the focus has been on the content, not the container, in terms of the obligation to, on the one hand, preserve, and then on the other hand, to produce, if it is relevant to the particular matter. So, wheresoever and howsoever situated, if there is content that is relevant, there is at once that obligation to preserve and to produce, possibly produce, but certainly to preserve, if it relates to the pending or reasonably anticipated litigation or investigation. Now, how do we do that in a web-based world? We know that with Twitter, Facebook, MySpace, blogs, Wikipedias, all manner of new web-based or internet-based content, that the trend is toward collaborative versus structured information. All of the things that have been mentioned, or many of the things that have been mentioned by Dominic, work well with what I would call conventional or structured information. So email has a structure, Microsoft Office documents have structures. But when you get to web-based information, Twitter and the like, you have to look to different technologies to capture iterations of those systems and that content. Otherwise, you're not able to see what that website looked like 2 years ago, on October 2nd, 2010. And that may be a requirement in your particular situation. There are some technologies that have been developed based on what's called the WARC standard, W-A-R-C. It's basically an acronym for Web Archive. And if you've ever seen the Wayback Machine on the internet that captures in a public setting iterations of certain websites, this is the kind of technology that has been made more sophisticated for the commercial market. And one of the early companies to do this actually got its start developing an archive method for web-based content for the UK archives. And the name of the group is Hanzo, H-A-N-Z-O. I have had an opportunity to observe that in action, and it's really quite amazing that it can point at Twitter, it can point at Facebook, MySpace, any of the social networking sites. It can point at SharePoint, any web-based content, and create a rendering both in native format and in PDF format that could then be put in a structured database for linking and searching, so that you can actually see what the depth of the links take you to from a particular website, internally facing or externally facing, on a particular date and time in the past. So it's, if you've ever dealt with interwoven or a technology like that, it's kind of interwoven on steroids when it comes to web-based content. That technology, now that it does exist, and there are a couple of competing organizations whose name escapes me right now, but if you want more information, just send me an email. That kind of technology does raise the potential standard of care. That is to say, do corporations now have an obligation to at least consider the use of that kind of technology to capture iterations of web-based content, if that web-based content might reveal what they thought or said about say a particular product at a point in time. So consider a pharmaceutical company that is in research and development, marketing and sales, has internally as well as externally facing collaborative information. Is there an obligation to preserve that? Well, certainly we've seen from some of the case law recently, that is to say from 2010 onward, that courts have ordered the disclosure of social media information. One case in particular, the Romano versus Steele case out of New York, dealt with a situation where somebody was suing for personal injuries arising from an accident. And the opposing party sought discovery of the individual's MySpace and Facebook account to see whether there was anything posted there in terms of information or images that might be relevant to her claim that she was seriously injured and in fact was not able to function physically to work. The court in that case ruled that the MySpace and Facebook account did need to be disclosed, and it reasoned that if there was information there that was relevant, the other side had a right to see it. The information was disclosed. It revealed pictures and notes about this individual doing zip lining in Costa Rica after the date of her accident. And anyone who's ever done zip lining, well, I have not, but I understand it can be a bit strenuous. And certainly if you're claiming that you have a debilitating back injury and neck injury that won't allow you to work, zip lining probably isn't in the picture. So that information then was brought forth at trial. A number of other cases in the United States have ruled that social media information is indeed discoverable. Some of those cases distinguish between the publicly facing parts of the social media site and those parts that are more private or limited to, say, family and friends. So the jury is still out in terms of whether courts in the United States, whether the majority rule will say everything is discoverable, or only those things that are available to the public. You know, this whole issue of social media does, I think, collaborative versus non-collaborative information to deal with, rather than collaborative versus structured information. So as we increase the use of the cloud, for example, and things are not even kept on premises, let alone in any formal structured way, I think this debate will continue and will only get deeper.
Thank you very much, Jim. Are there any questions or comments? No? Okay. So this concludes our eDiscovery panels. Fred, you have a question? Yeah. Would you like to?
Thanks. Jim, I was wondering if you run into this situation. There is a web group. That's why I kind of flinched on the question because I can't remember the name of it. But what they do is they create a internet chat capability amongst employees of the company. So they target a company. I think it's called like Hummer. Yeah, that's it. So what they do is they go to Company X and they send out emails to all the Company X employees and they say, hey, we're setting up this social networking site for you all. And then the employees, it's free for them, so they join up, and now all of a sudden there's a lot of discussion about the company and stuff that normally would be kept private. And then they go to the company and they say, hey, you got all this private information that's out there, and if you want to lock this down and make it a private group, it's going to cost you X amount of money a month. So it's basically holding your data privacy at ransom. And I just ran into that with a client. I was wondering if you or other people in the panel have experienced that.
Yeah, I think Yammer is a particularly interesting example where there could be very highly relevant information, and if then the piper's not paid to preserve that, are you guilty of spoliation? And to the extent that you open up your environment to your employees to that kind of technology, it raises those cost and risk considerations. Risk of potential spoliation, downstream cost of having to deal with that and have the technology to deal with that. I think similar issues of if you try to manage that by policy, telling people that they shouldn't use like Yammer or instant messaging internally for unique relevant information relating to legal holds. Just how do you manage all of that? What about corporate blogs, which are, similar or akin to the YAML, but even more kind of sanctioned by the company? Corporate Wikipedias. In technology companies, for example, it's been my experience, we represent a number of them, they still have a very, very open system. And the focus is on, an open environment. A lot of innovation, creativity, they believe, is spawned by having their employees be able to access resources internally as well as externally. They don't close down ports, for example, to external instant messaging or external email sources. They encourage the use of these collaborative technologies. And I think it does raise a question, what are they buying, so to speak, in terms of risk? Risk of privacy issues, risk of eDiscovery issues.
I have a question for my own panel. What is your opinion for the following question? There has been a development of data mining techniques. I'm thinking about Facebook. Facebook is looking now for patterns among its 800 or so million users. It's establishing social graphs, interest graphs, activity graphs. My question, do you think those algorithms, those techniques will eventually be used to prove a case in court, to data mine databases and use the case in court network?
If your question is specifically about Facebook, I won't venture.
No, it's
an
about
opinion.
databases.
But about the use of some techniques that don't involve what might be called traditional search, but
Yes.
rather look at patterns of association. It's already the case that if you really want to understand what's happening in email, you have to do pattern analysis. It really may not depend at all on the specific, say, keyword content of an email message, but maybe the act of an attachment, who it's sent to, what group of people forward that information on, how they normally relate to each other, how their behavior changes during a window of time. All of that may be important evidence to determine a claim or not. And there's no way that can be described as an ordinary search. It really requires, you mentioned graphical models, but it's beyond graphs in a way. It's interaction, transactional modeling that may also be time sensitive. And there are techniques that have been developed to do this sort of thing rather effectively, but I think the courts are still pretty far away from using them.
Well, that would be my follow-up questions. Will that kind of evidence ever be accepted by courts?
I think to the extent that an argument can be made, if you have access to the evidence, then you can get expert testimony on what it means. I think some court somewhere at some point will have to take it into account.
I think one of the important issue with that type of information is when you look at evidence and the obligation of a party to disclose or produce it, in most jurisdictions what's important is the very existence of that information. So if with your example, Facebook constantly do data mining and generate reports and stats and graph and things like that, then yes, they could be compelled to produce the evidence if it's relevant to a case. However, I think the big questions that come out of that is, what about if we had the capacity to do it, but it hasn't been done before the litigation? And I think so far, judges in most jurisdictions have agreed not to compel a party to do something and basically create evidence. But with the number of technologies that are available, the number of companies out there, almost everything becomes possible to a certain extent. And I think where there's going to be a big debate is about the creation of that information and then its retention. Which retention period should be applied to which type of information in order to see if the evidence existed before the litigation or investigation started, and if so, they're going to be compelled. If not, then I hope they won't be compelled to generate that information.
And to expand on Dominic's point, I think it increases the importance of companies, organizations to know themselves, to know what kind of information is being developed in terms of pattern recognition or pattern algorithms with respect to their technologies in play. Because they will certainly be held to be on actual or constructive notice of how their data is being mined. And I think that might give rise to an obligation to at least to take measures to deal with that, both from a privacy perspective as well as an eDiscovery perspective. I agree with Dominic in terms of the law currently. I don't think there is any expectation that companies actually mine their own data themselves. But if they are subject to a technology or buying into a technology that is doing it, I think they may be held to be on notice of that.
Are there any more questions?